Judgment in the appeal, Multi-Link Leisure Development Limited against North Lanarkshire Council.
The dispute in this case is about the meaning of an option clause in a lease of land at Cumbernauld. The land was leased to the appellant, Multi-Link Leisure Developments, for development by it as a pay and play golf course. The appellant was also given an option to purchase the land at any time during the period of the lease. The price that was to be paid for the land, if the option was exercised, was to be determined by the landlords according to a formula that was set out in the option clause. Neither party seems to have contemplated when the lease was entered into that the land might be used for residential development. It has, however, now been identified in the local authority's planning documents as being in an area which has a potential for urban expansion led by housing. This has given the land a development value, if sold in the open market, which far exceeds that which it would realise if it were to be sold for use only as a golf course. The price which has been determined by the landlord under the option clause takes full account of the development value of the land. The appellant contends, however, that the meaning and effect of the option clause is that the price should be for the land on the assumption only that it is suitable for development as a golf course. Its claim that the landlord's approach was wrong succeeded in the outer house of the Court of Session, but the judge's decision was reversed in the inner house. The appellant has now appealed against the decision of the inner house to this court. The option clause is not very well drafted, and it is far from easy to work out exactly what it means. In this situation, the court has to try to give a sensible meaning to the clause as a whole. There is no limit to the use to which the land could be put once the option is exercised and the appellants become the owners of it. So it is clear that the appellant's construction of the option clause would provide them with a very substantial windfall at the expense of the landlords. It is hard to believe that this is what the parties intended when the lease was entered into. If reasonable commercial parties had directed their minds to the issue, they would have agreed that the option price was to be the full market value of the land, taking account of any potential for development. The Supreme Court has concluded that this is indeed what the clause means, and that the appeal must be dismissed.
Decision in the Queen against Maxwell.
Lord Rodger.
By a majority, the court dismisses the appeal. There are dissenting judgments by Lord Brown and Lord Collins. The court's reasons will be published when the retrial has taken place.
Appeal for judgments. The Public Service Board versus Omar Maraj.
For the reasons contained in a judgment which I have prepared, this appeal is dismissed with costs.
The board will now adjourn.